Good morning, everyone. This is Dr. Claire Broughton. Today we'll be discussing parties to offense, to a criminal offense, and we'll be looking at the criminal liability of each of the participant to a criminal offense. So you'll see through this chapter that the law imposes different liabilities to parties who preceded the crime, who weren't at the crime scene, and also to parties who assisted after the crime. So they have different liabilities. Let's look at this particular case introduction. So Joey, Ross, and Chandler plan a scheme to rob the local bank. Ross is assigned to drive the getaway car. Since he does not own an automobile, he borrows Rachel's car. The three men drive to the bank. Joey enters the bank while Ross remains outside in the car. Chandler stands as lookout just inside the bank, while Joey points a pistol at the bank employee and collects several $1,000s. Joey and Chandler exit the bank and flee in the car. The three decide that they need a place to hide out and go to their friend Monica's apartment. Monica agrees to allow the trio to stay at her place for a few days. What is the criminal liability of each? So if you were looking at common law, Joey, Ross, and Chandler all participated in the crime, right? So Joey and Chandler would be principals in the first degree, since they were the individuals who entered the bank and collected the thousands of dollars. And Ross would be a principal in the second degree because he was present at the crime scene and he assisted. He was he was the driver for the getaway vehicle. And then Monica would be an accessory after the fact because she allowed the three, Joey, Chandler, and Ross, to stay at her place, and she basically provided post-crime assistance. Now let's look at the common law parties to the crime. So this particular slide tells us the liabilities of each of the parties to the crime under common law. The principal in the first degree is the individual who performs the actual criminal act, or the actus reus. So it's spelled A-C-T-U-S, first word. Second word is R-E-U-S, actus reus. The principal in the second degree is present at the crime and assists the principal in the first degree, but does not perform the actus reus. The accessory before the fact aids and abets the crime, but not present at the crime scene. For example, the person who supplies the weapon for the crime of murder, knowing that the offender who commits murder would actually use the gun to commit murder, or the person who provides the getaway vehicle. Those would be accessories before the fact. An accessory after the fact provides post-crime assistance with knowledge that the crime occurred but did not participate in planning the crime. Let's look at Texas law of parties. In contrast to common law, wherein there are different liabilities and distinctions between the participants to the crime, Texas does away with all these traditional distinctions between accomplices and principals. So what are the criminal responsibilities of a party to the offense? A party to the offense is liable for his own conduct and conduct of others for which he is criminally responsible. Are traditional distinctions between accomplices and principals followed under Texas law? No. So each party to the offense may be charged and convicted without alleging that he acted as principal or accomplice. So if you live in Texas, you would be charged for the crime without your participation being designated as principal or accomplice. So those distinctions no longer matter under Texas law. What is personal and vicarious liability? Section 7.02 of the Texas Penal Code provides for vicarious liability. What does this mean? It means that one person is held criminally responsible for the conduct of another. Even if you yourself did not commit that act, if you are criminally responsible for the act of someone else and that person committed the crime, you would be held liable too. There are three situations of vicarious liability. First, aiding an innocent or non-responsible person. Second, intentional assistance, encouragement, and direction. And third, breach of legal duty. An example of aiding an innocent or non-responsible person is given in this slide. So let's look at this first case. Oliver Twist, who is 10 years old, is controlled by a career criminal, Fagin, in Victorian England. Fagin houses runaways and orphans and trains them to be pickpockets. Who is criminally liable and why? In this case, it would be Fagin, who would be criminally liable for Oliver Twist's criminal activity. Because first, Oliver Twist is 10 years old and he would possibly not be subject to criminal liability. He is innocent. Under most statutes, if you're 10 years old and below, you would be considered a minor and you would not be liable. You would not be charged or criminally prosecuted. Let's look at the second case. Dan, an adult, sends his 12-year-old brother Paul into the store to shoplift a six-pack beer. Who is criminally liable and why? Here again, it would be Dan, the adult, because his 12-year-old brother is not responsible or he's not innocent. Oh, he's innocent, sorry. The second situation of vicarious liability would be intentional assistance, encouragement, and direction. Let's look at this case. Dan hires Dennis to kill his wife, Pam. Dennis agrees to perform the act for $5,000. Dennis hails a taxi driven by Igor. Dennis tells Igor to drive to an apartment house at 2209 Bobby K. Marks Drive, which is Pam's residence. Upon arrival, Dennis tells Igor to wait for him. Dennis goes to Pam's apartment and kills her. He leaves, enters a cab, and asks Igor to drive to the airport. At the airport, Dennis pays a fare and never sees Igor again. Can Dan and or Igor be prosecuted as co-principals for murder? Here, let's look first at the liability of Dennis. Obviously, Dennis would be liable for killing Pam because he is a person who actually who actually shot or killed Pam. How about Dan? He would be liable because he intentionally assisted, encouraged, and directed the crime. He paid Dennis $5,000 to perform the act, so he would be liable. Okay. How about Igor? Igor provided the getaway vehicle, but in this case, he would not be liable because he's just a taxi driver, right? And he did not provide intentional assistance, encouragement, and direction. He did not know that Dennis would be killing Pam at the residence, and he simply was there to provide a taxi service to Dennis all the way to the airport. Let's look at Texas rule. So under Texas rule, they have what is called the mere presence rule. The general rule is that presence in the crime scene is not enough. There has to be both presence at the crime scene or intent, or presence at the crime scene and encouragement. So intent should be present when you're at the crime scene, or encouragement should also be there. So for example, if you're at the crime scene and you're merely silent, you don't give encouragement, or you don't intend for the crime to be committed, you're not liable. The only exception would be if you have a legal duty to act, so that mere presence at the crime scene is enough. For example, if you're a correctional officer or a prison guard and you see two inmates attacking, assaulting each other, you as a correctional officer have a duty to prevent that assault. Let's look at this case. At the party, Dan, Dennis, and David decide to gang up on Paul. Dan shoves and hits Paul in the head. Dennis stands by but shouts words of encouragement to his buddy. Beat him harder, he deserves it. David hands Dan a bat that Dan uses to club Paul repeatedly. Who is criminally liable and why? So here, Dan, Dennis, and David would all be criminally liable, right? Dan is the person who committed the actus reus. He was the one who shoved and hit Paul on the head. Dennis was present at the crime scene and shouted words of encouragement to Dan. On the other hand, David also seemed to have the intent that Dan assault Paul because he handed Dan the bat, which Dan used to beat up Paul repeatedly. So all three are liable. The third situation of vicarious liability would be breach of legal duty. Breach of legal duty must be coupled with intent to promote and that particular crime and the failure to make a reasonable effort to prevent the crime. Is mere presence enough? Let's look at this case. It's State versus Walden. In this case, George Hoskins beat Alan Warden's 1-year-old son repeatedly over an extended period of time until he was bloody. Walden looked on the entire time the beating took place, but did not say anything or do anything to stop the beating. What do you think? Is Walden liable in this case? So the court said that mere presence is not enough, okay? So it means that in this case, unless Walden did something to promote that beating or failed to make a reasonable effort to prevent the crime, then he's not liable. However, Walden is the father of the son, of the 1-year-old son. He has a legal duty to prevent the beating because as a father, you have to protect your son from the beating. And the Texas Penal Code states that it's a parent's legal duty to protect the child. So in this case, Walden would be liable under the Texas Penal Code because he did not prevent the assault and he was the father of the 1-year-old child. Let's look at issues in law of parties. Let's look at anticipated crimes. Are unanticipated crimes, would they make the parties liable for that unanticipated crime? And this particular case illustrates what happens when a co-conspirator commits a crime that the conspirators did not agree upon. So here in this case, Dan and Dennis decide to give Pam, a 16-year-old, a pill, okay, to lower her inhibitions so that she will agree to have sex with them. The plan succeeds and Pam agrees to engage in sexual intercourse with the two men. While Dennis and Pam are engaged in the act, Dennis becomes angry and chokes her to death. Is Dan liable for the acts of Dennis? Okay. First, Dan and Dennis would be liable for sexual assault, okay, because Pam is a 16-year-old, cannot give consent, so sexual assault of a child. Now, let's look at this. Dennis basically kills Pam and chokes her while they are engaged in the sexual act. Dan and Dennis only agreed to the sexual intercourse, right? Would you say that murder should be anticipated in the crime of rape? Would Dan have foreseen that Dennis would have killed Pam while he was engaged in the sexual intercourse? In this case, no. The court said that Dan should not be liable for the murder charge against Dennis because the murder was not anticipated. It was not in furtherance of the conspiracy to commit sexual assault. Let's look at the second case. Zelda hires Scott to go to Maynard's apartment and steal his priceless Van Gogh painting. Scott slips into the apartment but encounters Maynard before he can take the painting. A struggle ensues and Scott kills Maynard. Is Zelda liable for Maynard's murder? In this case, yes, because in the case of burglary, you could anticipate that violence would occur if there was someone inside that particular apartment, residence, or building. So Zelda would be liable for the death of Maynard because it was and it should have been anticipated, and because it was in furtherance to complete the conspiracy of burglary. Let's look at section 7.02b. That's the responsibility of conspirators. So here, this section states that conspirators are responsible for acts in furtherance of the unlawful purpose. So the crime should have been anticipated as a consequence of carrying out the conspiracy. Okay, so for you to be liable for a crime that was different from what you had agreed upon, your co-conspirator should have committed the crime and able to benefit the conspiracy. Issues in laws of parties. One issue is the imposition of the death penalty. The Supreme Court said that the death penalty cannot be imposed on an accomplice who did not intend to kill or was not recklessly indifferent to human life. Let's look at this case. Dan was assessed a death penalty by a lower court for being a principal in the second degree in a robbery murder case. The vehicle in which Dan was riding overheated. While his two conspirators went to the house to ask water for the car's radiator, Dan remained in the car. Unknown to Dan, his two associates decided to rob and kill the elderly residents of the house. Can the death penalty be imposed on Dan? No, this cannot be imposed. You cannot impose death penalty on Dan because Dan, although an accomplice, so first he was not an accomplice. He did not know that the two people who were in the car would go in and rob and murder the elderly residents of the house. Another issue in the law of parties is what happens when a co-defendant is acquitted. Would another defendant who was charged also need to be acquitted? Let's look at this case. Bonnie and Clyde are charged with robbery. Clyde committed the act and Bonnie served as lookout. At trial, Clyde was acquitted as principal. Can Bonnie be convicted as an accomplice under common law? How about under Texas law? Okay, so under Texas law, you can still convict Bonnie because the acquittal of Clyde may have been purely personal to him. For example, Clyde may have been acquitted because of insanity or because of some other grounds that is personal to him. So in this case, Bonnie can still be convicted despite Clyde being acquitted. So let's look at the Texas Penal Code. Section 7.03 provides, in a prosecution in which an actor's criminal responsibility is based on the conduct of another, the actor may be convicted on proof of commission of the offense and that he was a party to its commission. And it is no defense that the person for whose conduct the actor is criminally responsible has been acquitted, has not been prosecuted or convicted, or has been convicted of a different offense or a different type or class of offense or is immune for prosecution. So here, it basically reinforces that what I said earlier, that even if a co-defendant was acquitted, you yourself may be convicted, okay, based on some other proof. So let's look at pre-crime assistance. First, there has to be intent. You would be charged most likely with separate crime. For post-crime assistance under Texas law, this would also be separate offenses. Examples would be tampering with or fabricating evidence, hindering apprehension or prosecution, interference with public duties, resisting arrest, search, or transportation, abuse of a corpse, or misprision of a felony. For example, if you fail to report a felony. Under the accomplice testimony rule in Texas, a conviction of a defendant cannot be based on the testimony of an accomplice. It requires corroborating evidence. So if you committed a crime and an accomplice testifies against you, your conviction cannot be solely based on the testimony of that accomplice. There has to be other separate evidence that proves that you committed the crime. Let's look at the criminal liability of corporations. First, what is a corporation? Our corporation is an artificial person with legal capacity to act. Under British law, there will be no corporate criminal liability, and it would be the individual employees who would be liable. Under the United States law, corporations can be subject to federal criminal law for acts of agents that benefited the company. There are two theories by which the actions of employees can be attributed to the corporation so that the corporation would be liable for criminal acts of its employees. The first theory would be respondeat superior, or if you translate it, it would be let the master answer. So this theory is imposed to make corporations liable for misdemeanors committed by their employees. The corporation would be liable for acts of agents or employees in the course of their employment. Under Texas law, criminal liability would attach to the corporation if the employee, whether menial or executive, acted within the scope of his authority and for the benefit of the company. So as long as the employee was acting, acting according to his responsibilities based on his job description, and his actions benefited the company would be liable. Second liability theory, which is imposed on the corporation for felony offenses, would be if it were official policy of the corporation. So if the misconduct was ratified, adopted, tolerated by a majority of the governing board or high managerial agent, then the corporation would be liable for acts of its employees. So what is a high managerial agent? Corporate officers or others who are authorized to make corporate policy. For example, the vice president, the president of a company. So in several years ago, the Wells Fargo started telling its employees, bank account employees, to open accounts, fictitious accounts to open fictitious accounts in order to meet their quota. So bank employees, bank tellers started opening fictitious accounts in the name of friends, acquaintances, family, in order to meet their quota. Now this would be a crime because their families or friends did not actually open a bank account, so it would be fraud. Okay, so if it was official policy of the corporation, then the Wells Fargo would be liable for the acts of its employees. Let's look at this case. Dan, the bookkeeper of Bearcat Inc., a company organized to buy and sell books at a discount to students, makes false entries into the financial records of the corporation. What is the liability of Bearcat Inc. if Dan made the false entries to cover his embezzlement of money from the company? Why? Here, Bearcat Inc. would not be liable because Dan made the false entries for his own benefit. It wasn't to benefit the company. Let's look at the second question. What is the liability of Bearcat Inc. if Dan made the false entries so the company can avoid paying taxes? Why? So here, Bearcat would be liable for the acts of its employee Dan under the theory of respondeat superior because his actions benefited the company. So how do you impose penalties on corporations? First, monetary fines, right? But what about non-corporate entities? So there are some organizations that are not organized as corporations. They're not organized as, with the INC at the end of their name. So they are just loosely organized as an organization without them being corporations. How do you impose liability on them? Let's look at this case. Fraternity brothers at Alpha Beta Chi are conducting their initiation ceremony of neophytes. Part of their initiation requires physical hazing. Alex dies as a result of blunt trauma to his extremities and cardiac arrest. Dan, the Grand Archon, was not present at the crime scene, but was summoned after and brought the body to the hospital. What is the liability of Alpha Beta Chi? Okay, what is the liability of Dan? Here, the fraternity brothers would be liable. Okay, they would be personally liable for the death of the neophyte. Okay, how about Dan though? He was not present at the crime scene. Would be fair to impose criminal liability on him. So he brought the body to the hospital. He should not be liable, right? Because he did not provide assistance to the crime, and he did not do anything post after the crime. Thank you very much for listening to this lecture. I hope you have a good day, and please don't forget to do your assignments on Blackboard.